All right, hi, this is James Zhang, and today we are here with Mauricio Rauld. How's it going, Mauricio?
How you doing, James? Good to see you again.
Yeah, thanks for jumping on. So, I guess to start off, just tell people 30 seconds what you do.
Oh man, I help people stay out of jail. That's my new thing. Look, I'm a syndication attorney, right? So I do everything that relates to syndication. I personally do all the syndication work. We've got Carrie in our firm that does all the real estate, the transactional work. We do all the entity formations. We do all the asset protection, and I also associate with the estate planning piece. But so that's kind of what the firm does as a whole. 100% of my practice is real estate syndication. So I just help clients raise capital legally and essentially making sure they're complying with all the rules and regulations so they stay out of jail.
So there's a lot of general partners out there who are coming to our conference, who are out there raising money right now, and I guess let's hit those top five. You said there was top five ways to stay out of jail, or not, the things they should know to stay out of jail. There you go. I got it. All right.
I finally wrapped up that ebook called The 5 Things Every Syndicator Must Know to Stay Out of Jail, which honestly, the title's a little bit out there, but you know, the odds of you going to jail are very slim. But I wanted to get people's attention because this is serious stuff. So like violating securities laws is serious business. And I think a lot of people take the rules kind of very cavalier. They don't really follow them, or they don't check with attorneys, and they just don't think it's a big deal. And there's so many people out there that are violating securities laws right now, either not knowing or thinking they're outsmarting the SEC and structuring things in certain ways. So I wanted to put out that ebook so that I could just kind of lay out step by step right now what the top 5 are. You know, maybe next year they'll be different, but these are kind of the active things that I see every day.
Maybe can we touch on the top 5?
Sure. Like
all right. At a high level.
At a high level, real quick. So the first one is clearly people not realizing they're issuing securities. Okay. People come up with all kinds of excuses to say, well, it's not a security, it's a joint venture, it's a promissory note, it's whatever. They try and.
So they have no registration. No registration.
No exemption. A lot of the first-time syndicators don't even know. They just don't know any better, right? They're buying real estate. Like, why is the SEC even involved? But even the more seasoned ones are like, well, I'm structured in such a way that it's not a security, when the reality is the structure itself doesn't matter. Is anytime you're taking money from investors where the returns are generated by your efforts, it's a security.
Okay. Number 1. All right. So they don't even do the 506B, 506C. Okay. All right.
Number 2 is advertising. You know, most people rely, as you know, the rule is generally you have to register your security, find an exemption, or it's illegal. Most people rely on an exemption called a 506B, which we don't have time to get into, but essentially that prohibits you from advertising. And for some reason, people don't think that posting things on Facebook and LinkedIn and talking about things on podcasts don't constitute advertising, when they absolutely do. So that's another violation that I see all the time. And it's not just talking about your specific deal, but there's something called conditioning the market. Getting people excited in general, that can cause people problems. And so if you're doing a 506B offering, just stay off of social media, stay off of podcasts, and just don't get on there.
Yeah, I love the Facebook post that's like, feeling really excited about later this afternoon when I'm like...
It's crazy. Or the you know, and again, everybody tries to get cute and outsmart, and everyone's like, the other favorite one is the due diligence videos. Oh, we're here at the property and we're doing this and we're doing that. And it's possible to do that correctly, but inevitably people say, oh, if you want more info about my offering, or hey, if you want to ask me about, they just cross the line. I'll give you a quick tip there. If you want to do a value add, just add value to your listeners when you're doing a due diligence trip, just do a video on here that, I love the top 5, but here are the 5 or 10 things you should look for when doing a due diligence visit. And you should get your camera and go into the units and record what you're doing and just teach people what you should be looking for when you're doing due diligence. That's totally fine. Okay. But when you start talking about investors and, I'm looking for money, that's where you cross the line, obviously.
So, no advertising 506B, advertising 506C.
Yes, if you're going to pick one of those 2 exemptions, that's the main difference.
All right, number 3.
Number 3 would be, not understanding what a pre-existing substantive relationship is. It kind of goes along the lines of no advertising. Generally, you show no advertising by establishing a pre-existing substantive relationship. You can't just go meet somebody at a conference. Unfortunately, we're not doing your conference this year live, but last year it was an amazing conference in person. I don't know how many hundred people were there. people were meeting people all the time. You can't just meet somebody at your conference, go home, and then pitch them a deal under a 506B. You've got to establish a substantive relationship, and the ebook goes through the 8 steps, and there's a questionnaire and all that fun stuff. But that's just understanding what it takes to get to that level of establishing a substantive relationship.
So you're saying someone goes to the conference and they get their business card and they just blast them with a deal. That's not legal. That's what you're telling me.
I get blasted all the time because I go to these conferences as an attorney, as either a sponsor or just attending. So I'm passing out, I think I'm passing out my business card is pretty obvious. Look, my firm's called Premier Law Group. I mean, I'm clearly the lawyer, but I get emails all the time, a week later or a month later with they're pitching me deals, and I've never even spoken to them. I've never had a phone call with them. Nobody sent me a questionnaire. Nobody's figured out if I'm accredited or non-accredited, or if I'm sophisticated, or what my goals are. Boom, I just get an email.
All right. Are we on number 4?
I've lost track already. One of the other things that is a big deal, and it's really annoying, and it's just, it's frustrating, but it is what it is. It's just is people raising money. There's all these sponsors that just go from one deal to another deal, from one sponsorship to another sponsorship group, and they're just raising capital for that particular deal. They're not part of the company. They're just basically, they have an ability to raise capital, and they just go from deal to deal, from sponsor group to sponsor group, raising capital. And there's a very good chance that you are acting as a broker. You're in the business of basically soliciting funds to not your deal, but somebody else's deal. And there's all kinds of ways people try and package that. But at the end of the day, if you're getting transaction-based compensation, you're a broker. If you're not doing substantial duties, a legitimate co-sponsor where the majority, your primary role, the majority of your time is doing the thing and not raising the capital, you're potentially running into broker issues, and you're basically acting as an unlicensed broker.
That is scary for a lot of people.
Yeah.
And so, was that number 4?
I honestly, off the top of my head, lost track. But you know what else we should talk about real quick is the new accredited investor
yes, go ahead.
guidelines, because everybody's super. I think everybody. Honestly, I've been off of social media for a little bit. I'm just getting a little tired of everything I'm seeing there. But everybody kind of asks me when I'm doing calls, "Hey, what about these new rules? Can I get to them?" And the answer is basically no. Here's what happened: is they expanded the definition of an accredited investor, and the two that are the most relevant to us are, number one, is if you have a certain type of license, a FINRA registered license, if you have a Series 7 or a Series 82 or a Series, I forget the other one, but basically if you're an investment advisory type brokerage, license, then you will now be considered an accredited investor, irrespective of your income or whatever. So that's not exciting, because, if I meet somebody who's non-accredited, they're not going to go get I don't think so. I don't think they're going to go.
You would absolutely know if you have this license. This is not like you fell over and you got this license.
You're going to have to take an exam. You're going to be under not an obscene amount, but you're going to be under some regulatory. You're going to be under FINRA. You're going to have files, audited financials. I mean, there's a lot of compliance that goes along with having these rules. These Series 7, Series 82s, and I forget the last one off the top of my head. I can't imagine somebody saying, "Hey, do you want to invest in my deal?" They say, "No, I'd love to, but I'm non-accredited." They're going to go run out and get a Series 7. I mean, you could, but it's going to take you months. You got to study for an exam. You got to take an exam. You got to do an application with this. I mean, it's just,
you might as well try to be accredited then.
You might as well. Now, here's the exciting part. So I want to make sure everybody, here's the exciting part about this, is the new rules said that they are going to, in the future, it kind of opens the door, they are going to come up with other forms of accreditation, meaning instead of having to go take a test and get a Series 7 license, there might be, and we don't know what it looks like, but there might be some other accredited institution where I can go to some company, take courses. I don't know if that's a weekend course, a month course, a year. I don't know what we don't know what that's going to look like. Take an exam, pass the exam, and now I have a certification that says, "Hey, I passed the exam," and that's going to be good enough to become an accredited investor. That is a little bit more exciting, but it's not here yet. That's just, we're going to figure that out in the future. So,
right.
Maybe the next video we do, we find out, hey, you can go to this company that's, that's been licensed by the SEC or the states, and now you can go take hopefully it's a weekend course or something. It's not hopefully it's not going to be a 6-month or a year course you got to take, but whatever. There's an exam. You're going to get a certification, and that's going to make you accredited, which is exciting. One last thing that people talk about, which is complete nonsense, is there's a rule there also that says if you are a knowledgeable, sophisticated employee of the issuer, you will be considered accredited. First of all, none of these issuers have any employees to begin with. You're a sponsor, you've created a brand new company. That company you're not even an employee of that company.
Right.
So this is really meant for, let's just give you the example. When Facebook, prior to them going public, they needed to raise capital, and they were raising capital in the private markets. If somebody in their company was an employee of Facebook and they were involved in all the capital raising, and they were not accredited, but they were sophisticated enough and they were an employee of Facebook, that would trigger it. But again, unless you're going to have an investor hire that investor as a W-2 employee in order to get them to become an accredited investor, that's not really going anywhere either.
Yeah,
so,
they're going to put 50,000 in, and then you're going to pay them $50,000 back. Like, it doesn't make any sense.
Right.
Right.
So the exciting thing about the new rules is really the foundation that was set for what's coming down the pipeline. And we don't know the time. This is the SEC. I don't know if it's going to happen next month, next quarter, next year, but at some point we'll get an announcement that says, whatever, there's a school that got basically opened up, and you can go to the school, take a test, pass it, get your diploma, and now you're accredited.
So when in the process should people reach out to you?
As soon as, well, if people reach out to me, actually, I was going to say as soon as you get an LOI accepted, because at least then you know exactly what property you're looking into, what market. We can have sort of intelligent conversations. Honestly, people reach out to me earlier because I help a lot of clients with structuring. Are you going to do a 506B, a 506C? Are you going to do a fund maybe instead of a project specific? Are we going to do a fund, an opportunity fund? What are the pros and cons of all these things? So you can reach out to me as early as you want, but most people are ready. They email and say, Mauricio, we just got into contract. My LOI was accepted. What's next?
Okay, perfect. Well, I appreciate it. We will have a link for people to get the book. What is the best way for people to reach you? Is it email, website? What's the best way?
They can go to my website at premierlawgroup.net, or I'd love for everyone to check out my YouTube channel. I've been putting some videos there, a lot of great videos there. I'd love a subscribe. Or you can just go through the website. There's a way to contact me, and I'd love to talk to anybody who's interested.
Thank you very much, Mauricio Rauld.
My friend, I appreciate it.